Thank you, Sari, and thank you all for being here today. It's a pleasure to be here and talk to you about my work as a scholar. It's of course a great honor and achievement to become a professor. So I'm very happy to have so many of our PhD students here that can, celebrate this moment. Important for me, but also for our center. I'd like to say it's a great pleasure to be part of this community of University of Eastern Finland. I do not know how many of you don't know yet, but the Center for Climate Change, Energy and Environmental Law is one of the largest centers of its kind in the world. So it's a great community to be part of. And we just had a fantastic PhD retreat here in Colli to celebrate that and also to do what we are meant to be here to do, which is to share with others our learnings. So today I thought I would tell you a little bit of my most recent research on just transition litigation, but at the same time connected to threads of work from my past. As Sari said, my journey started as a scholar at the University of Copenhagen, where I did my PhD. Those years were, for those who don't know, marked by the negotiations on the making of the Paris Agreement, and this is how I landed at the University of Copenhagen. I had a scholarship to work on specific aspects of the lawmaking process that went into that treaty. Of course, everybody expected to have a Copenhagen Agreement at the time, which never happened. So that meant that I just had to target my efforts towards that objective for a week longer until we had a Paris Agreement in 2015. At that point, I was already a postdoc at the University of Edinburgh, where I was part of a great team of international environmental lawyers. I was working on two different European projects. One was focusing on land uses, emissions from land uses and the regulation, and the other one was working on benefit sharing arrangements under a set of multilateral environmental treaties. From Edinburgh, I decided I want to stay in Scotland, and therefore I got a tenured position at the University of Stirling, first as a lecturer, then as a senior lecturer, and there I have to say the kind of work I did started to change, because with the adoption of the Paris Agreement, my focus on international lawmaking shifted into implementation. So I started looking more closely to the practice of implementation of international and European law obligations associated with climate change. Something called Brexit, you may have heard about it, forced me to look at things I've never looked at before, so focusing closely my attention to the implications of entangling yourself from the obligations of EU law and what does that mean for the practice of an environmental lawyer. So looking really at close issues of environmental law at the domestic level, something that I still do today because I sit on the body that was on the board of a body that was established by the Scottish Parliament after Brexit in order to oversee the compliance of public authorities with environmental law. And it's really a dramatic change from the negotiations of the making of the Paris Agreement to start looking at these issues, and certainly I couldn't see it coming, but it's definitely an interesting way of viewing your journey from the practice of making of the law to the implementation at the national and even at the subnational level. One thing that I want to mention also about my journey is that when I was in Stirling, I had the good fortune of achieving a certificate in learning and teaching at the university level, which is, I think, a very important thing to do, and we have to remind ourselves all the time that we are teachers as well as researchers. And this is something I take great pride in. Now, the presentation today deals with a specific area of research that has preoccupied me a great deal in the last few years. I edited a special issue of a journal called Journal of Human Rights and Environment. Human rights and environment is one of my key area of specialization. And at that point in time, we were, after the adoption of the Paris Agreement, looking at the interplay between human rights and climate change law. So this special issue dealt with that topic. And my friend and colleague Joanna Setzer and I had the idea, why don't we look at climate litigation that relies specifically on human rights law? We thought it was a neat, small project that we could handle in a couple of months or something like that. It has taken us years of work, and the result of that work is enshrined in this paper that I cite on this slide. That work initiated another strand of work of which I will speak today, and it's coming up in Nature. It was a lot of work to get a paper published in Nature, but it's coming out in November. Joanna and I were joined by many other scholars and colleagues from other universities. And the idea is really to try and understand the phenomenon that I tried and describe in the limited time I have available to you. So this is what I'm working on right now. Joanna and I, while looking at the phenomenon of climate change litigation, and I'm sure you've all heard about it because it's all over the news. The journalists love to talk about cases where governments and other entities are being brought to court for not doing enough on climate change. So when we looked at this very sexy, invisible phenomenon, we realized that there was the other side of the moon, as we conceptualized it in the beginning. What is the other side of the moon? It's that widespread but unnoticed litigation whereby common people, small people, complain about what? About the various policies and projects and activities that are undertaken to make the transition happen. I'll provide you a couple of examples in a minute to make this idea more concrete, but the concept is that there is a lot of opposition that is articulated by means of litigation to climate action. And this is not, as I said, as well visible as climate litigation, yet it is happening. And at the aggregate level, we really know very little of this phenomenon. The first example I wanted to bring you just also to see how this is linked to my old research and the journey that brought me here, comes from a phenomenon that is now not as visible as when I worked on it 10 years ago or so, but it concerns projects that are aimed to keep forests standing as opposed to cutting them down. It's a very topical topic here in Finland today. But this was already an issue that was discussed widely in the past, because in developing countries, these conversations has already happened. And the issues that you are experiencing today in Finland have been experienced all over the developing world, where people were objecting to new policies constraining what they could do with their forests and the intrusion of the state into the personal and private sphere of individuals and or collectives. And what the research already at the time showed is that restrictions over access and uses of forests was leading to abuses of rights and the legitimate interests and opposition, some of it articulated in the form of litigation. Same story, different context, in the context of renewable energy. This is work that I did a few years later. I was working at that time with a brilliant PhD student who did a lot of field work in Mexico, where a lot of wind energy farms led to widespread human rights abuses. We're talking about killings. We're talking about intimidation, land grabs, inadequate working conditions. And again, a lot of this opposition is here formulated in the form of litigation. So what does this tell us about these activities that are meant to secure climate action but end up creating perverse outcomes? Well, it led me and my colleagues in a workshop that we held a couple of years ago now to sit down and discuss what is this that we are seeing? How can we define this phenomenon? And we came up with a terminology of just transition litigation that you may see used in a number of reports now. The Business and Human Rights Center this year published a data set that is inspired by this work. They were also at the workshop. They try and identify litigation that raises questions over the justice and fairness of climate policies and projects. And it's important to note that this litigation is not about climate change. These applicants normally don't really care. Or if they may be supportive of climate action, but not done in the way in which it is done. But many times it's fair to say they may even be agnostic and really not be interested in preventing climate action ex se. One of the things that we do in the paper is to identify frames through which we analyze these justice claims made in just transition litigation. And clearly we did not invent anything, but rather rely on established notions that are entrenched in the literature on environmental justice, energy justice, climate justice. So what we did is to import that thinking into our analytical frame in order to analyze the phenomenon of just transition litigation. Now, it's fair to say that we are even in the early stages of this activity, in the sense that we are identifying data collections that are suitable for our exercise of analyzing the data, and then coming up with what? Well, the frames of justice that are being used. We want really to understand what are the legal arguments that these applicants are making, and how successful or unsuccessful they are, and what they reveal us about the distribution of burdens and benefits in the transition, the perceived fairness of climate action, as well as who is really opposing or standing, in, if you like, in court in these cases. So, why are we doing this? This is probably the more important question. We're doing this because we are trying to understand a social phenomenon that is unfolding before our eyes and is going to accelerate the more policies and activities to facilitate the transition are adopted. I think you can see this in Finland very clearly, but this is a common story and it's happening everywhere. Our intuition and hope is that studying this litigation will help us understand what impacts it has on governance and whether it really can put a spanner in the wheels of the transition. And even if it doesn't, what the implications are. We really want to understand how climate policy can be done better so that the grievances of those groups that are affected are better factored in, so that the transformation that is associated with the transition is inclusive rather than exclusive. We bring people with us rather than doing this against the people that have to live with the consequences of the policies and projects that we are implementing. And I think I'll leave it to that, and I very much welcome any questions you may have. Thank you.